Hey everyone, Mike DeBliss here. Welcome back to the webinar on demystifying the FBAR. We're now up to Module 6, Certifying Non-Willfulness. Now, when I talk about certifying non-willfulness, I'm talking about certifying it for purposes of the streamlined procedures. As many of you know, one of the most critical requirements of the streamlined procedures is that the taxpayer certify that his or her failure to report the foreign account was non-willful. Now, the problem with that is that while it's explicitly stated that the taxpayer certify that his conduct was non-willful, there's not much guidance on what the textbook definition of non-willfulness is. And when you think about it, what the IRS should have done was provided taxpayers with a definition, a working definition of willfulness, and then build off of that and describe or give examples of non-willfulness. Instead, we are left with this very vague term, non-willfulness, that is the centerpiece for making a streamlined submission, whether it's a domestic streamlined submission or a foreign streamlined submission. So how do we deal with this very nebulous term that oftentimes could mean the difference between whether your certification, your streamlined submission rather, is accepted or whether it's rejected? The best way I've seen the concept of willfulness explained is by Jack Townsend, author of the very popular Tax Crimes blog. Professor Townsend views the path between willfulness and non-willfulness as lying on a continuum. Now, when I think of a continuum, I can't help but think of an electromagnetic spectrum with these ultraviolet radiation and with all the different shades of colors. That harkens back to an age when I was in high school, and I remembered studying this topic in physics. Unfortunately, it was a very it's a very painful memory because I remember how difficult it was to kind of wrap my head around this topic. But nonetheless, the best example here to help illustrate the concept of willfulness is an electromagnetic spectrum. So when I ask you to visualize an electromagnetic spectrum, I want you to focus on the two extreme ends. On one extreme end, we have short wavelength radiation, which is gamma rays, and at the other extreme pole, there's long wavelength radiation, which an example of which would be radio waves. So those are our two extremes. We have short wavelength radiation at one extreme, and an example of that is gamma rays. And then at the other extreme, we have long wavelength radiation, which is radio waves. So I promise you there'll be no more science beyond this point. But I only use the scientific terms here to illustrate what we are now going to replace those terms with for the extreme poles for our purposes. So focusing on these extreme poles, what I want you to do is substitute not willful for the short wavelength pole and definite willfulness for the long wavelength pole. Now, as Professor Townsend so eloquently explains, the facts of some cases will present themselves so far in the direction of one of the extreme poles that determining whether the conduct is willful or non-willful will be as easy as finding a free drink in Las Vegas. Um, and as many know, that is not hard to do. So we have these two extreme poles. We're merely substituting not willful for one extreme pole and definite willfulness for the other extreme pole. And as is the case in some situations, the facts of some case will present themselves so far at the extreme end of the electromagnetic spectrum that they will clearly be cases of not willful or definite willfulness. And so determining a person's conduct in those extreme cases is very easy. And so, as you can see in point 2, these are what might be considered slam dunk cases for a specific type of disclosure. For example, the taxpayer who falls on the definite willfulness end of the spectrum should not think twice about applying to the offshore voluntary disclosure program. Why? Because his conduct is willful. On the other hand, a taxpayer who falls on the not willful end of the spectrum might be able to consider a variety of options, from making a quiet disclosure to making a streamlined submission. And so there's no confusion. What I am referring to when I say a quiet disclosure is merely going back and filing delinquent FBARs for the years in question. Typically, you go back 6 years in time when you're filing delinquent FBARs because the statute of limitations for asserting an FBAR penalty is 6 years from the date that the FBAR was supposed to be filed. But keep in mind that a foreign bank account that should have been disclosed in 2005, the taxpayer had until June 30th of 2006 to actually file the FBAR. So the 6-year period, or the statute of limitations period, would begin ticking not from the last day of the year that the taxpayer failed to report the account, but from June 30th of the year following the year that the taxpayer should have reported that account. I'm not trying to confuse you, but I just wanted to be very clear what it means, or where when the clock starts ticking for purposes of the statute of limitations. The point here is that there are times when determining whether conduct was willful or non-willful is so clear, it's as clear as day. And as I described before, if the taxpayer falls on the definite willfulness pole of the spectrum, then the obvious choice is the offshore voluntary disclosure program. On the other hand, the taxpayer who falls on the not willful pole of the spectrum might be able to consider a variety of options. And here I offer the following disclaimer. Just because I mentioned 2 possibilities doesn't mean that you should automatically assume that a quiet disclosure is appropriate. As in all cases, this information is very general, and I always advise the person seeking advice to retain a private attorney to do a complete risk assessment. That way you can be sure that you are making the right decision when it comes to the type of disclosure you're making. Now, Professor Townsend poses an insightful question. What about when the facts lie at points other than at the extreme poles of the spectrum? Meaning, what if it's not a slam dunk? And what if that needle is lying somewhere in the middle, in the very middle of the spectrum between the 2 poles? in what we might refer to as the gray area. And and on that point, how close must the facts be to either end before one can confidently make a decision? Now, the worst case scenario is when the facts are in the middle, and that's obvious. When you're in the gray area, and the facts could go one way or the other, that's when things get murky. So when the needle on the willfulness spectrum is not pointing at one of the extreme poles but is vacillating in the middle, those cases present a real challenge. And if there was ever a time when a tax attorney is needed to do a risk assessment, that would be it. You need someone who has the expertise as well as the experience to evaluate the facts and to do a risk-benefit analysis and take the harmful or damaging facts that point in favor of willfulness and balance them against the facts that show non-willfulness. And that is a very tedious task and is best left for a professional. And there are cases and there are times when facts that might at first blush appear to suggest willfulness, there are times when those facts can actually infer non-willfulness, meaning there could be a neutral or benign explanation for something that might otherwise cause that needle to vacillate towards the willful end of the spectrum. But unless you speak to a tax attorney and have that tax attorney do an assessment of your individual case, you'll never know. So without further guidance, the tax community might just have to settle on the approach taken by Justice Stewart when he was attempting to describe pornography. I know it when I see it. So again, I can't emphasize enough the importance of consulting with a tax attorney and not leaving this up to chance. So to restate the obvious, assessing willfulness, not to mention the corresponding risk of prosecution, becomes exceedingly difficult in these fringe cases where the needle is in the middle of the spectrum. And again, as I discussed before, it requires nothing short of a thorough balancing of the facts both for and against. Now, at the risk of stating the obvious, what you should understand is that in dealing with these gray areas, there will always be risk. It's simply inherent in a willfulness assessment. It's the equivalent of accepting the fact. It's the equivalent of, for example, doing a bungee jump or parachuting out of a plane. Even though the odds are that you're going to be safe and that you're ultimately going to to land on the ground with your firmly on your 2 feet, and that you're going to be able to go on living your life just as you did before you strapped on that parachute or that bungee cord, there is still a risk. But what it comes down to is, how much of a risk is it? And if you want to take that out, if you want to extrapolate that out to the most extreme case, I mean, when we get in our car every day and we drive our kids to school or we drive to work, we're operating a piece of machinery that can easily get into an accident and kill us or injure us as well as other drivers on the road. However, the risk of that happening is very small. And so it's necessary to understand that when determining the risk of willfulness for purposes of certifying non-willfulness, there will always be risk. No matter how benign the facts of the case are, no matter how much of an oversight the failure to report your foreign account might have been, there will always be risk, um, um, regardless of which program you seek to follow. And so here, a quote that is used by many tax professionals: a taxpayer not at material risk for prosecution is not the same as a taxpayer at no risk of prosecution. So again, we deal with this in terms of the risk or the percentage of risk that is likely to appear in a given case. Now, that should speak to you in a very unique, in a very special way. And what do I mean by that? Well, this whole concept of risk is not for the faint of heart. So anybody who's going through this process has to be willing to assume at least some risk, especially if they are looking to make a submission through the streamlined procedures or come into compliance by filing delinquent FBARs. And the reason why I point out those two examples is because there's no immunity from prosecution under either one of those scenarios, streamlined or filing delinquent FBARs in what we might call a quiet disclosure. Essentially, the taxpayer is completely vulnerable to any one of a number of parade of horribles. And while criminal prosecution is very unlikely, the possibility of the IRS asserting onerous FBAR penalties in the case of a quiet disclosure isn't. So again, if this whole concept of risk is making you a nervous Nelly or making it difficult for you to sleep at night, and if you're just plain old averse to risk, then oftentimes the best solution is to seek shelter in the OVDP bunker and put yourself out of your misery rather than subjecting yourself to any further agony. Within the Offshore Voluntary Disclosure Program, the taxpayer has or is has a strong I don't want to call it guarantee, but a strong commitment that if he does as he's asked within the program and is fully transparent and forthcoming, that the IRS will not refer the case to the Department of Justice with a recommendation for prosecution. So it's not it's not an ironclad guarantee of immunity from prosecution within OVDP, but it's damn near close to that. And so that explains why the risk averse should that have a fear of their case being referred to the Department of Justice should take advantage of OVDP. Now, I'd like you to take note of the following here. Tax Notes Today published an article summarizing some events at the Federal Bar Association annual conference. A Carolyn Cirolo, who is now the acting Assistant Attorney General and who's pending approval of the nomination of of Kono Namorado to be the Assistant Attorney General was quoted as saying the following. Boy, what a mouthful these names were. I apologize if I've butchered them. Quote, "We are taking particular interest if we find evidence of an account holder claiming non-willful conduct in a streamlined compliance filing or delinquent submission only to find that evidence produced by the Category 2 banks suggests otherwise. We are using information gleaned from the program to open new investigations, pursue new targets around the globe, and we will continue to do so as the information is developed." Now, why do I raise this statement that Ms. Cirolo made? Well, I raise it for this reason. Some taxpayers, despite having a case that is on the fringe and that isn't a slam dunk case for streamlined, and perhaps could go either way in terms of willfulness, some taxpayers insist on making a streamlined submission. Now, that is almost the equivalent of trying to fit a square peg into a round hole. And this is why it's so important to be careful. While it's easy to think that if you make a streamlined submission, you mail it out with a check, assuming it's a streamlined domestic submission for the offshore penalty, which is 5%, that everything is after that is going to be honky-dory, and you will be brought into full compliance with your U.S. tax obligations. While that is sometimes the mindset that taxpayers have who are on the fringes, we now have very explicit guidance suggesting to us that or disabusing us of that notion in cases where non-willful conduct may not necessarily exist. So I highlight for you the first part of this of Ms. Cirolo's statement. Once again, we are taking particular interest if we find evidence of an account holder claiming non-willful conduct in a streamlined submission or delinquent submission only to find contradictory evidence. And she expounds on that by stating contradictory evidence in the form of evidence produced by Category 2 banks or otherwise. So it's very important to know that the IRS is going to scrutinize your streamlined submission, specifically the non-willful certification, and if they come up with any information that contradicts your certification, they are likely to open up a full-scale examination and basically follow the trail, just like they are, just like a dog would follow the scent of a just like a dog would follow the scent of another animal, like a bloodhound would follow the scent of a fox. So they're going to pursue things and see where it takes them. So it's so important to understand that, if you make a streamlined submission, don't assume that everything is going to be honky-dory and that everything is going to be well. They are clearly scrutinizing these with a fine comb, and as Ms. Cirolo has indicated, if they find evidence that contradicts the certification, then they are going to be hot on the trail. Now, is there any risk of audit under the streamlined procedures? Well, I just mentioned that very briefly in the last slide. Returns submitted under the streamlined procedures are not automatically selected for audit. Once again, returns submitted under the streamlined procedures are not automatically selected for audit. Instead, they're subject to what's called a verification. There is a distinction between an audit on the one hand and a verification on the other. So what the heck is a verification? Well, the examining agent can request account statements and other relevant documents to verify the information reported. That's all that a verification includes. It's the examining agent contacting the tax professional or the taxpayer and requesting other information to verify the information that was reported on the streamlined form itself. Now, a recent IRM procedural update that was dated back in August of 2014 shed some light on what type of streamlined submissions might be ripe for exam under the streamlined procedures. This procedural update is very, very important, and it gives us a lot of keen insight into what type of streamlined procedures might cause a little bit of a riff in the IRS and might be ripe for examination. So let's get right to it. What are the triggers here? That the IRM listed. Here they are. If there are at least 5 foreign information returns in the taxpayer's streamlined submission, then the agent is instructed to refer the case to the Large Business and International Division of the service. Now, the purpose of such a referral is not so the taxpayer can be entered into a drawing for a 3-day cruise aboard the Disney Magic, or to be entered into some sweepstakes. Instead, it's quite the opposite. It likely means that an examination is on the horizon. Now, I want to be very clear here. The IRM procedural update that I'm referring to doesn't say hands down that if the taxpayer makes a streamlined submission in which there are 5 foreign information returns that have been prepared to accompany the submission, that will automatically trigger an exam. That's not what the procedural update has said. Instead, it tells the agent that he or she must refer the case to the LB&I division of the IRS, the Large Business and International Division. We as tax professionals, however, reading between the lines, know that very likely that will very likely lead to an examination. So I don't want to mislead you here, but at the same time, I don't want you to think that the referral to the Large Business and International Division of the service is merely an academic move, and that it's just a mere formality. Please disabuse yourself of that notion. If such a referral is made, it likely means that an examination is on the horizon. And once again, what we're talking about here that triggers the referral of the case to LB&I is a submission of at least 5 foreign information returns as part of the taxpayer streamlined submission. And I've listed a few different international reporting forms that qualify as a foreign information return for this purpose. There is Form 3520, Form 3520-A, Form 5471, 5472, 8938, 926, or 8621, and of course the FBAR is in there as well. So it's very important to hone in on that, because that could potentially put an entire streamlined submission in jeopardy. So let's get right to some practical advice on how to prepare your explanation of non-willful conduct. This is some general advice. Again, it's not customized to your individual circumstances. And as I've said time and time again, it's critical that you consult with a tax attorney to get advice on whether your case is one that is good, or that is good for a streamlined submission. Only a tax professional can help you make what could potentially be one of the most important decisions that you make. And so that's how important this issue is. But here is some general advice for preparing a non-willful certification to accompany your streamlined submission. First, tell your story. Now, when I say tell your story, I'm referring to much more than just blanket denials. So it's so easy sometimes to get into the mode of denying, that you never really get into anything substantive, meaning an explanation as to why you inadvertently failed to report your foreign account. For example, you can shout from the rooftop that you were non-willful from now until eternity, and even shed a tear along the way. But unless you explain why your conduct didn't run afoul of willful blindness, the IRS is likely to view your denials no different than the thief who denies stealing an iPhone from Target despite being caught on a surveillance camera removing the phone from the shelf, stuffing it inside his jacket, and walking out later. Just as you probably thought, oh my, how foolish it is for the thief to have, done something, like stealing a phone off the shelf of a Target in front of a surveillance camera. It's no different than than a situation where you're shouting from the rooftops that you were non-willful in a non-willful certification. It's a very similar example. And as you see here, the IRS will view this as nothing more than self-serving. And that's why it's important to really drill down and explain what the cause of your oversight was. At the same time, you don't want to give a dissertation, you don't want to write a thesis, but you want to address the issues that you anticipate the IRS is going to want answers to. And it's oftentimes better to deal with them in advance than to wait for the IRS to ask you those questions later on. It dampens the shock value if you come right out of the gate and you address the issues that you know are going to be on the IRS's mind up front. It shows that you are being completely transparent and forthcoming, and that you have a logical explanation for the oversight. Second, your certification should include objective supporting evidence. This is part and parcel of what I've been talking about, drilling down. In a Forbes article entitled, "Am I Non-Willful Under the Streamlined Procedures?" Charles Rettig, an expert in the field of foreign asset reporting, wrote, quote, "What objective evidence might exist to demonstrate a lack of personal knowledge by the taxpayer about their foreign reporting requirements?" So that is the seminal question that should be running through your head. What objective evidence would show or demonstrate that I had no knowledge about my foreign reporting requirements? Third, you must directly confront the presumption, as unfair as it might seem, that the IRS will impute a sinister motive to your failure to report your foreign bank account. Namely, they'll presume that you were willfully blind. What do I mean by willfully blind? Well, we've covered this in an earlier module, but by willful blindness, it's essentially where the taxpayer digs his or her head into the sand like an ostrich and refuses to confront something, to confront the obvious. Meaning, it's the taxpayer who knows perhaps just a little bit about the FBAR reporting requirements, but just enough to know that they apply to him, but doesn't look any deeper into the FBAR reporting requirements to confirm what he thinks is the truth, or confirm that it doesn't apply to him. So a common example that that I like to use here is this. It could be a person who perhaps has applied to college, and as we all know, we've applied to college at some time, or professional school. It's the equivalent of getting that slim envelope in the mail. And as we all know, the slim envelope often contained a rejection letter, whereas the thick envelope contained, usually was the acceptance letter that contained all of the accompanying paperwork that we needed to sign up and fill out before we arrived on campus. So we can oftentimes tell by the size of the envelope whether we've been accepted or rejected from the school. A student who gets a letter in the mail, a thin letter in the mail from their favorite school that they apply to, suffice to say, will know that letter, that the contents of that letter contain a rejection. But perhaps he or she isn't able to confront the reality that it's a rejection letter, and perhaps they'll just fall apart if they physically open up the envelope and read what they suspect is 2 or 3 lines stating, "Thank you for applying, but we've rejected your application." That's the principle behind willful blindness. It's knowing that something. It's knowing something beyond a hunch, that it is perhaps negative, or it perhaps applies to you, but not wanting to confirm it objectively by opening up the envelope and reading the contents and coming to the realization that something that you were hoping for has fallen through the cracks, and that disappointment. So I'm trying to bring real world examples into tax law, which isn't necessarily easy to do, to breathe some life into this concept of willful blindness. Now, Mr. Rettig shed some light on this concept. He says that the following are the most critical questions that have to be answered in order to rebut the presumption that, quote, you made a conscious effort to avoid learning about the FBAR reporting and record-keeping requirements. And I should back up before I list them for you. The definition of willful blindness is a conscious effort to avoid learning about the FBAR reporting requirements. So willful blindness, I should say, in the context of FBAR reporting is defined as that. Willful blindness is a theory which broadly applies to not just FBAR reporting requirements, but to other areas of the law and for example, structuring, other crimes involving financial means. So these are the critical questions that Mr. Rettig raises. First, did you inform your return preparer that you had an interest in or signature authority over a foreign bank account? Second, did you ask your return preparer whether it was necessary to report your interest in a foreign bank account? If so, what was his answer? Third, did your preparer go beyond providing a tax organizer that recites the Schedule B reference relating to an interest in a foreign bank account? In other words, did he take the time to explain what types of foreign interests are reportable? So as you can see here, the answer to these questions definitely sheds light on the issue of whether the taxpayer was willfully blind or not. Moving along to number 4. Again, we're talking consequences of making a bad choice. I hate to get into this topic, but it's one that is critical to address, especially in a webinar that is general like this. There are consequences of making a bad choice. You must thoroughly invest in due diligence to avoid what could potentially turn into a parade of horribles, and which have been known to drive many a sane taxpayer to the brink of insanity. You must tread very carefully and not take the streamlined procedures lightly. If your non-willful certification turns out to be a bad judgment call on your part, then all you will have succeeded in doing is making a bad situation that much worse. What do I mean by that? Well, if your non-willful certification is rejected, not only will you become ineligible for the streamlined procedures, but you could be subject to any one of the following parade of horribles. And I think I know why I hate this part of the presentation. I really feel as though it's lecturing to a child. I don't have my own kids, but I was one of those kids growing up that was footloose and carefree. I never liked to be lectured to. In fact, I hated it beyond anything. And yet I now feel as though I'm in the shoes that my parents filled, where they were lecturing to me when I was younger and I was falling off the beaten path. Yet this issue comes up time and time again, that it does have to be emphasized and it does have its proper place in this part of the lecture. So what am I referring to when I when I say parade of horribles? Well, if you choose wrong and your certification is rejected, the first problem you're going to have is that you'll be ineligible for the offshore voluntary disclosure program. Essentially, once you make a streamlined submission, it's too late to apply to OVDP. It's either or. It's OVDP or streamlined, not let me try streamlined, and if my streamlined submission is rejected, well, then I'll jump into the OVDP bunker and enjoy, the immunity from prosecution and be able to know with precisely what my offshore penalty will be. That's not how it works. You have to make the right decision up front because there's no going back. If your streamlined submission is rejected, you are no longer eligible for OVDP. In that case, your only remaining option for coming into compliance with your U.S. tax obligations would be to file amended 1040s and delinquent foreign information returns, in most cases FBARs, in what is otherwise known as a quiet disclosure. The risk, of course, is that your case could be referred to the Criminal Investigation Division of the IRS for investigation. CI, in turn, could refer your case to the Department of Justice Tax with a recommendation for prosecution. Unfortunately, that doesn't end the parade of horribles. To the extent that the IRS obtains evidence that directly contradicts your non-willful certification, it could refer your case to the Department of Justice with a recommendation that you be prosecuted for perjury. Now you probably, if you haven't been overwhelmed already, I had to guess, your head is probably spinning around in circles right now. Perjury? What are you talking about, Mike, when you say perjury? Well, remember that the non-willful certification, including all statements made in the streamlined submission itself, are made under oath. All right, so everything that you submit in your streamlined submission, regardless of whether it's contained in the non-willful certification part or in response to a question on the form itself, you're answering those questions and making those statements under oath. As a result, if the IRS were ever to obtain evidence that contradicts any answers or statements that you made under oath, they could refer your case to the Department of Justice with a recommendation that you be prosecuted for perjury. Yes, perjury is a criminal offense, and it is punishable by fines, and as well as potential prison time. So it's very important that you understand what risks lie when it comes to making a streamlined submission. And I speak specifically to those taxpayers where it's not where the issue of willfulness is not a slam dunk, and where the needle is vacillating in the middle of the spectrum, and where where there may be just as many facts pointing towards willfulness as there are facts pointing towards non-willfulness. You must understand that not only is there a risk that the streamlined submission is rejected, and that the case is referred to CI for an investigation, or the case is opened up for a full-scale audit, but you also have this issue that the IRS could refer the case directly to the Department of Justice with a recommendation that it be prosecuted for perjury. And again, this goes to what we talked about earlier, that the IRS is gathering information on taxpayers' accounts all the time. And this is happening through FATCA, through John Doe summonses that the IRS continues to serve to banks. So there is a verification process going on, not just by virtue of the information that the taxpayer supplies the IRS with, but by independent information that the IRS is obtaining all the time. And if they have such information in the palms of their hand that contradict statements or answers that were made in your streamlined submission, that, my friends, could lead to a very uncomfortable brush with the Department of Justice. Remember that when it comes to a streamlined submission, the company line is that there will be what's called a verification, where the IRS may request you as a taxpayer to supply accompanying documents such as bank statements or receipts to verify the contents of your submission. However, there is no guarantee that the IRS won't open up a full-scale examination. While it's unlikely, it's still possible. So again, this gets back to the whole theme of risk. Those who are risk averse and who want to be safe should give very careful, should view their choices very carefully, because Streamline does not offer any guarantee of immunity from prosecution. And as I specifically point out here, the risk of an audit is there's always the risk of an audit. However, that risk is minimal. What we do know happens routinely is that there is a verification. So what I'm stating here is that you could be a heartbeat away from an examination. And as we all know, IRS examinations are not just a walk through the park. They have the potential to be just as painful as root canals. Keep in mind that the IRS, if they open up an examination, could assert multiple willful or non-willful FBAR penalties, and that those penalties are determined per account, not per unfiled FBAR. What this means is that your FBAR penalties could be aggregated, one on top of the other until they reach the stratosphere. So, my friends, I'm not trying to sound like the prophet of doom here. I'm merely trying to give you important information. And with this information, you'll be able to make a well-informed decision. This has always been my practice, not just as a tax attorney, but as an attorney in other areas of the law. What I always try to do for my clients is to provide them with all of their options and explain to them the consequences of going through door A, going through door B, going through door C. Then and only then are they armed with the information that they need to make a well-informed decision. Now, is that always the best decision? Unfortunately not. Some clients are set in their ways and want to do it and have a set way or a preconceived notion of how they're going to do something. But at the end of the day, we as tax professionals have to do our due diligence and provide our clients with all of the information, including the consequences, as as disheartening as they sometimes can be. It's far better to know what could happen up front as opposed to being ambushed by it for the very first time later on when it's too late. So I want you to know that my door is always open for you. As you can see, my contact information is up on the screen. Please don't hesitate to contact me anytime with any questions, and I'm always willing to jump on the phone and or answer an email. I will say this, however, that if you have a specific question, please call me, because it's when it's sensitive, I rather not answer it over email. It's far better that you call me and that we discuss the matter in detail. Look forward to seeing you in the next module.